Today we're going to talk about homemade wills. Look, there's no legal requirement that you use a solicitor or even a specialist in wills and estates to do a will. You can do it yourself if you wish, I guess. The requirements are that it's in writing. There are two witnesses that appear to be over the age of 18 years who witness your signature, and they don't benefit under the will, nor are they married to someone that benefits under the will. I guess you could do it yourself. The problem with homemade wills isn't so much that you're not allowed to do it yourself, is that in my experience, people generally don't get it right. And the reason for this is simple. You know what you mean and you write it down, but then you pass away and we can't ask you. Our office has spent lots and lots of energy asking a judge or judges to tell us what the will means, because a homemade will generally is quite imprecise. The rules of understanding a will is that the will's supposed to speak from itself, all the four corners of the will, to interpret it, but sometimes it still doesn't make sense. By way of example, I give my entire estate to my two children. The next clause, I give my house to my daughter for her life. Well, which is it? The entire estate going two ways, or the house for the life? Which one is to prevail? After lots of negotiation, after lots of legal fees, after lots of asking a judge to tell you what it means, we eventually can find out what it means. And that's the problem. The executor isn't allowed to make a call and put their finger in the air and go, I think I know what it means. A Queen's Counsel told me what it means. I'm sorry. Unless the judge declares what it means, or all those affected by the will agree as to what it means, there's going to be a fight and there's going to be a lot of expense. So please, if you're thinking about doing a homemade will, don't do it. And best, use a specialist in succession law, that's wills and estate, and get it right.